McLennan.
Yes, one of the issues which was raised with us earlier was the change in respect of the power of remittal. And this is actually relevant to the final stage of the JG decision as well, which you hopefully still have at page 1235. But the position in respect of the scope to remit to the Secretary of State was that that was a power available under Section 70 of the Nationality, Immigration and Asylum Act 2002, Section 87.
Power available to tribunals.
Yes.
Yes.
Yes. That was the subject of an amending repeal on the 20th of October 2014, at which point the option was for remittal only to the tribunals, not to the Secretary of State. So that change occurred between the upper tribunal decision in JO, that was still in place, and the decision in MK. So between those two decisions, the scope for remittal to the Secretary of State was lost by virtue of that
between
amendment.
which two cases? JO
and MK.
And the fact that the case was ongoing, it came in immediately,
Yes.
regardless of when the proceedings had started.
Yes, that's the effect. And then there were amendments to the FTT rules. There were 2014 rules enacted, which had a more expansive inquisitorial function, which more or less dovetailed with that change. Same day, yes, enacted on the same day. So,
Do we have copies of the
You just sent those.
yes, they were sent in. You don't have, well, Section 87 as originally enacted had the power to remit. That was repealed in its entirety in October 2014.
So that's the FTT rules that has been sent to us by email.
Yes.
That's the new enacted rules
Yes.
that came in 2014.
Yes,
Thank you very much.
exactly. The loss of that capacity to remit to the Secretary of State was the subject of consideration by our Court of Appeal in the JG decision. You'll see that at page 1235, paragraph 36 and following. Paragraphs 37, 38, 39, the Court of Appeal expressed their view that it would have been preferable if there was still a power to remit to the Secretary of State, because he or she was better placed to deal with these matters. But after a long discussion of that, it's recognised that that's lost, that's not possible, and the alternatives are limited. And in that case, the Court of Appeal remitted back to the first tier tribunal.
Am I right in thinking there's a distinction between remittal to the Secretary of State by the Court of Appeal and remittal by tribunals? It does seem from the structure of the appeal, the statute governing the appeals, which is section 14, I think, that the Court of Appeal never had the power to remit to the Secretary of State. And I think it's dealt with by the Court of Appeal in the case now before us at 53. Section 4, Northern Ireland Court of Appeal was obliged to confront the reality that under Section 14 of the Tribunals, Courts and Enforcement Act 2007, remittal to the Secretary of State was not an option. I don't think it ever was.
No.
Under the 2007 Act. That Lord Justice McCluskey goes on to deal with it with the question of remittal by the tribunals at 62 to 64. The options available to the relevant tribunal, he says at a number of points. And he refers to the fact that that was changed.
Yes, and it's referring to the rules that we're talking about at the end of paragraph 64.
Yeah.
The new rules from 2014.
Yes.
Yes.
Well, you've now given us chapter and verse. Thank you very much.
All of that, yes. In JG, the court appeared to be, back in 2020, of the view that there was scope to remit to the Court of Appeal, but that was not possible. Obviously, it's been acknowledged now in the JG decision. There's another intriguing final component to the JG decision, which goes back to the question Lady Rose was asking me earlier about the slightly oblique reference to taking the matter back to the Secretary of State. And you'll see discussion in paragraph 41 of a certain class of appeals where the tribunal opted to make a final order, the effect of which would be to require the Secretary of State to consider the case afresh.
Sorry, paragraph 41
of JG. This is page 1237. Sorry.
Sorry. Yes. Sorry.
So this is a reference to cases where the tribunal found the decision under challenge was not in accordance with the law. And cite two judgments there. And then the Court of Appeal speculates if this course is a matter of jurisdiction available, then whether to adopt it will be a matter for the first-tier tribunal, and in the event of a further appeal hearing, the UT. So that appears to be the sort of creative solution possibly available to take a matter back to the Secretary of State, notwithstanding the removal of that provision in section 87 of the 2002 Act. So that sheds some light on what the upper tribunal was pondering in the MK case. So that's our Court of Appeal's decision in JG. And then we have something of a bellwether judgment of the High Court, which indicates the impact of this line of reasoning in actual immigration cases going forward. And that's the decision of the High Court in the case named JR 137, which is at page 1261. This is a judgment of Mr. Justice Schofield, and it demonstrates the reach of section 55.3 now after the JG decision. So this is a case involving a removal of two individuals and their daughter to Nepal. They'd been in Northern Ireland and the UK from 2009. Claimed asylum, that had failed, and there was an appeal in the first-tier tribunal. An appeal to the upper tribunal that was refused, and then a judicial review challenge brought to that decision. You see that from paragraph 10. Section 55 is considered then, from page 1263 onwards. And
so this was a sort of CART.
Yes, CART ELVA, Elevated Judicial Review Threshold case, exactly. The JG decision of the Court of Appeal is considered from paragraph 20, that's page 1266, and the High Court judge summarises what he considers to be the effect of that. And I'm not going to read all of this to the court, but to take the high point of it, you'll see at Roman numeral 5 on page 1267, it describes the key principles or critical requirements are that the child be listened to in order to hear what they have to say, and relatedly that their wishes and feelings are ascertained and taken into account, and describes how the guidance isn't prescriptive in respect of that. Goes on to say this might well require direct consultation with the child, depending on the circumstances, and the feasibility of directly consulting an affected child should be considered in each case. The terms of Section 55 guidance certainly appear to suggest such direct engagement. And this is again paraphrasing the Court of Appeal, where a simple, uncomplicated exercise is required by virtue of the obligation to have regard to the Section 55.3 guidance. It's difficult to conceive of a case where the failure to perform this will be excused. And that's JG, and cites the paragraphs there, and ED, which I'd also shown you, where the word absolute was used about the duty. So all of this is a paraphrase or a summary of the effect as the court construed it of our Court of Appeal's decision in JG. Then from paragraphs 24 onwards, there's a discussion of the elevated threshold for leave. This is the Cart Elba elevated threshold, which Lord Sales raised with me earlier. And you'll see the criteria there set out of paragraph 25. The judicial review raises some important point of principle or practice, or there's some other compelling reason for the court to hear the judicial review. Those are the criteria that are necessary to get leave in a case of this nature. Now, the feature of this case that's notable is that this is a case where there was detailed consideration of the best interest and welfare of the child. And you can see that from paragraphs 29, this is page 1270, onwards.
By the decision maker?
By the decision maker, yes. So you see the paragraph 31 describes what the Secretary of State did with the case. Noted that the Section 55 is referenced. There are 12 paragraphs in the decision letter dealing with it. Had taken into account the need to promote the safeguard and promote the welfare of children. Looked to the child's residence in the UK, the route she put down, her personal identity, friendships and so forth, and had placed considerable weight on the fact that the father and mother don't have leave to remain. It's reasonable to expect a child to return with their parents to their home country. And then further consideration of the impact on family life, and all of that culminates in a paragraph that's quoted there about the child being at a reasonable age to return to Nepal. Judge notes at paragraph 33, no mention is made in the letter of the Section 55 guidance, much less any detailed analysis of what it might require, nor is any evidence of consideration being given to any direct contact with the applicant's daughter to seek her first-hand input. The court goes on then at paragraph 39 to express itself satisfied that the first-tier tribunal judge did clearly address herself to the applicant's daughter's best interests, and no doubt did so conscientiously. But that is not the issue. In light of the case law discussed above, and particularly the case of JG, binding this court, an additional question is whether the FT judge also adequately addressed the requirements of Section 55(3) duty. In the FTT decision, there was no consideration of the Section 55 guidance or what it might have required in the circumstances of this case as regards listening to the applicant's daughter and ascertaining her wishes and feelings. Then discusses what was there, but no consideration appears to be given to by the Secretary of State to any direct contact with the child, which might have shed more light on these issues. So, notwithstanding the fairly fulsome consideration of the child and their interests, JG is clearly a problem. And then you'll see how the court observes that the Section 55 point didn't feature at all before the first-tier tribunal, and wasn't raised until we got to the stage of the upper-tier tribunal proceedings. Paragraph 43, the court again expressed itself in terms of the Secretary of State and the judge obviously considered the applicant's daughter's welfare and best interests. There was, however, no detailed engagement with what might separately be required by the Section 55(3) obligation at any point, and notes that it appears to be treated as adding nothing material to or being subsumed within the principal duty. On my reading of the authorities, including the decision of JG, that's an incorrect analysis of the law, and at least strongly arguably so. Then, in order to get permission or leave in judicial review, the case has to surmount the Cart Elba higher threshold, and the judge considers that it does. It elevates or breaches the threshold on the basis of the other compelling reasons. That's from paragraph 55 and following. And the reason it gets there, 58, is because there's a strongly arguable error of law. There appears to be no appreciation of the freestanding nature and importance of the obligation on the Secretary of State under Section 55(3), and no detailed analysis of what's required in this case or whether it was complied with. Then, interestingly, he observes, if a view were to be emerged in the tribunals, the requirements of Section 55(3) have been misinterpreted or overplayed in the line of authority culminating in JG, or they've been properly interpreted or unworkable, such that the guidance requires consideration. That should be addressed head-on in a reasoned decision capable of further appeal. But JG's binding as a matter of law, and he, on that basis, considers that leave should be granted. So, notwithstanding the elevated threshold, notwithstanding substantive compliance with consideration of best interests and the promotion and safeguarding the welfare, the court still is driven to grant leave to apply for judicial review. And I think that case was ultimately conceded by the Secretary of State. So that decision also plays into the decision in this case under CAO, because that decision was contemporaneous with a judicial review application in this case, which was also conceded by the Secretary of State on the basis that it would follow from JG that the court would find in favour of the applicant. So I describe this as a bellwether decision, but it shows the impact of the JG line of reasoning. It shows that we've elevated the threshold, put 55.3 and compliance with it above a whole substantive consideration of the welfare of the child, which the judge was satisfied had been dealt with by both Secretary of State and First Tier Tribunal. That was a position in the law of Northern Ireland that applied in 2020-2021. Then I moved to the fourth topic that I listed was the treatment of this in the Scottish courts and in Arturis in the upper tribunal. So the issue was before the Scottish Inner House of Session in a case of ZG, which you'll find at page 1486. And again, this is a criminal deportation case where the appellant is relying upon his relationship with his daughter, who I think was 9 years old at that time, to contest the deportation decision. Like a lot of these cases, no issue had been raised about Section 55 at the First Tier Tribunal or in the upper tribunal. The first time the point was raised was on appeal in the Court of Session, and there's some discussion of that, and notwithstanding the misgivings the court had about it, they allowed the ground of appeal to be taken forward, and you'll see that at paragraph 15 of the judgment, page 1492. The appellant relied upon the JG decision in the Northern Ireland Court of Appeal. You'll see that in the grounds of appeal, which are rehearsed at page 1493. It refers exactly to the statute provisions, the guidance and the JG authority in ground 2. And then the court records the competing submissions of the appellants and the respondent. The Court of Session's discussion of the issue begins at paragraph 30. And picking it up at paragraph 35, the court is noting that this is an 82(1)(b) appeal to the First Tier Tribunal, therefore not a judicial review or an ordinary appellate jurisdiction case, but one where, as Lord Seals observed earlier, the court can consider the matter de novo, and also, you see at the top of page 1497, where the FTT is an extension of the overall decision-making process in human rights cases. So the FTT function is of a particular character in a case of this type. And you'll see then, picking it up just by letter B, the Inner House of Session says the FTT tribunal has to decide for itself, on the basis of the evidence before it, whether the decision is unlawful under Section 6 of the Human Rights Act. Whatever the defects of the respondent's decision, it's the duty of the FTT to ensure the ultimate disposal of the human rights claim is consistent with the Convention, and that's classic authority MM from the Supreme Court. Then, paragraph 36, again, this chimes with some submissions I made to the court earlier. You'll see the Inner House say, generally, in a case where the article 8 rights to family life of a child is founded upon, the critical question will not be whether the respondent has breached one or both of her Section 55 duties. Usually the crucial issue will be whether paragraph 39(9)(a) of the immigration rules applies, and if it is not, whether the interference with the article 8 right is justified. In some cases, even though the respondent may have breached Section 55, the evidence before the tribunal enables it to identify and have proper regard in the best interest of the child as a primary consideration, and then actually refers back to the MK decision in support of that. And on their reading, JG in the upper tribunal in Northern Ireland doesn't suggest a different approach. So they then distinguish essentially the position of the Court of Appeal on the facts from this case. And the Inner House conclusions then at 38 are in essence that the first tier tribunal itself could consider the best interests, treat them as a primary consideration, that it did so, and it did so when considering the overall Article 8 case, and that they found to be in accordance with Lord Hodge and his principles as set out in paragraph 10 of Zumbas. So this is a case where the Inner House doesn't contradict the Northern Ireland Court of Appeal. It takes a different view on the approach and develops points of distinction between those two decisions. In Arturis, however, the conflict is more head-on, and that's the most recent decision of the upper tribunal. You have that at page 1050. So this is a June 2021 decision. And there's a head note on page 1050 which really summarises the issue. Under the laws of England and Wales and the law of Scotland, failure by the Secretary of State to comply with their duties under Section 55 is highly unlikely to prevent the tribunal from reaching a lawful decision in a human rights appeal involving a child, AJ India, ZG. Under the law of Northern Ireland, the position is different. And then they pose the question in the first paragraph, how, if at all, does a breach of the duty in Section 55(3) impact upon the determination by a first tribunal of an appeal against refusal of an individual human rights claim? So that's the issue framed. What then follows, and I won't take the court through all of this because we have actually covered a lot of the ground, is a very thorough analysis of the history of that case and the decision letter in that case is available at page 1056, and as is common with many of these, it does refer to the best interests of the child involved, does refer to Section 55 of the 2009 Act, and does engage in some substantive consideration of his interests. That's page 1056 through to 1057. From page 1061, you have again a very detailed treatment of the guidance, which we've already looked at. The relevant paragraphs 2.7 and 2.8 are considered at page 1065 and 1066. You will see the upper tribunal's commentary on the guidance at page 1068 in paragraphs 30 and 31. So the tribunal is looking at the actual duties that border officials will be engaged in, the nature of those duties, and the main situations where they will encounter children in the discharge of their functions. So again, looking at it with a fairly forensic focus on when the functions will be discharged. Then they look at paragraph 2.7 and the fourth bullet point, and note importantly, where parents and carers are present, they will have primary responsibility for the children's concerns. There's nothing in the guidance which states that immigration officials have an obligation to obtain or even to consider obtaining expert evidence such as psychological reports from social workers concerning what may or may not be in the child's best interest, irrespective of the child's own wishes and feelings. And they then turn to consider the case law. And this, I'll not take the court through all of this, but many of the lines of authority that we've looked at in the submissions this morning are then considered very closely by the upper tribunal in Arturis. So Tenizere is considered, ZH, Tanzania, AJ India, SS Nigeria. There's a full treatment of all of those decisions. And the tribunals engages in a discussion of the ZG decision from page 1106 onwards, Lord Doherty's analysis, which it finds favour with. And then begins the discussion section at page 1110. The approach to be adopted in England and Wales is summarised at paragraphs 105 and 106. So reference to AJ India, which I've taken time with this morning, at 105. 106, the tribunal says what this means is, even at the time when the appellate system included a duty to allow an appeal on the basis the respondent's decision was not in accordance with the law, a failure by the respondent's officials to comply with Section 5 was extremely unlikely to prevent the tribunal from reaching a lawful decision on the appeal, and then reference to ZH Tanzania. So 107, between the competing principle of respondents, the primary decision maker, and the tribunal's extension of the respondent's decision-making process, it's the latter principle which holds sway, and that accords precisely with SS Nigeria. And then the court refers to JO and MK and then turns to JG and conducts a critique of that decision. The upper tribunal looks back to ZH Tanzania in paragraph 24, which we began with this morning, at paragraph 113 through to 115, and doubts that her consideration of that issue was correct. The question for the purpose of Article 8.2 of whether the decision is in accordance with law is not necessarily determined by whether the actual decision is in accordance with domestic law. What is meant is whether the proposed interference has a proper base in domestic law, and it deals with that, saying Section 55 undoubtedly satisfies those requirements. Paragraph 120, the upper tribunal expresses the view that the conclusion in JG that there's been a procedural breach of Article 8 is incompatible with the approach taken in England, Wales and AJ India and the Inner House and ZG, by the procedural breach can be cured by the remainder of the decision-making process. And again, that's one of the recurrent themes of what we've been discussing in the course of the hearing today. At paragraph 125, 126, there's consideration of what's required from terms of evidence. And you'll see upper tribunal says Section 55.3, and this is paragraph 126, does not require the respondent to apply the guidance, merely have regard to it. Properly read, the guidance does not envisage the respondent doing more than to take account of the child's wishes and feelings. It does not envisage the commissioning by the respondent of independent reports, whether to determine the latter's wishes or feelings or identify any harm. Lastly, it needs to be pointed out, it's not the purpose of Section 55.3 to alleviate the procedural consequence of the appellant of bringing a human rights appeal. So, again, different from the Northern Ireland Court's decision. Paragraph 129, very starkly, the upper tribunal says, if this appeal were governed by the law of England and Wales or the law of Scotland, it would be clear the grounds of appeal could not succeed. And then goes into discussion of how there's a trans-jurisdictional effect in play whenever the tribunal's dealing with a case in Northern Ireland is governed by the appellate authority of the court of that jurisdiction. And that impels us to the conclusion that even though, had it been looking at the same case in England and Wales, it would have dismissed the appeal at paragraph 132, they conclude that they are compelled to set the first-tier tribunal decision aside and remit it back to the judge for a de novo hearing. So a very curious, odd outcome In substance, the upper tribunal is supportive of the first-tier tribunal decision, sees no flaw with it, but because of the authority in JG, is compelled to remit it back to be considered again by another judge. So that's the position we'd reached in 2021. The CAO appeal before this court then required some direct consideration of these competing approaches by the Northern Ireland Court of Appeal. And before I get into the little bit of detail on that, it might be useful just to see some of the background to the case that's before this court. This is a case where there's a human rights claim advanced in opposition to a removal decision by the appellant, and she's relying on a number of things. Risk of domestic violence from her husband, risk of genital mutilation to her daughter, and general human rights considerations. And the evidential sources, I won't go through these in great detail, but just to flag them for the court. There is an asylum interview conducted with the mother, which begins at page 621 of the bundle. So a very detailed, structured interview about her circumstances, the domestic violence in respect of her husband, the risk of genital mutilation to her daughter. All of that is examined in great depth in a structured interview. That then feeds into an analysis by the
Does she have a representative with her?
At that time, was she represented? I think she was. It's not clear actually if she had at that stage. The box for legal representative is unticked, so I'm assuming she didn't at that juncture. But I can correct that if that's wrong. There's then a detailed decision letter from page 647. This is April 2019 from the Home Office, and runs to over 150 paragraphs of consideration of her case. So just looking at a few components of that, on page 650, you have direct reference to the section 55 duty and the requirement to take into the Home Office to carry out its functions in a way that takes into account the welfare obligation, and in dealing with your application I've taken this into account, as stated. Then the nature of the claim is considered. You will see there's an Article 8 claim at page 652. There are convention reasons are discussed, which are the risks of persecution, domestic violence and mutilation of the daughter. There's detailed consideration of the risk of domestic violence from paragraphs 40 onwards, and again some of this cross refers to the interests of the daughter because the threats are linked to a belief in the importance of genital mutilation. You'll see consideration of the children's interest at paragraph 54. The decision maker finds it not credible that the applicant would be contacting her husband with a view to taking her children to the UK if she was actually concerned about risks from him. Then one has a very detailed consideration of the risks to the daughter from paragraph 56. And again, I'm not going to take the court through all of that, but it's examined objectively by reference to expert reports on genital mutilation in Nigeria. It's examined subjectively in terms of the concerns of the mother, and the decision maker expresses a number of concerns about the credibility of the account given by the mother. Paragraph 67 and onwards expressed doubts about her claim that there is a risk. You will see then on the summary findings of fact at the page 661, following facts are rejected. The risk of domestic violence, fear of your husband, and the daughter being at risk of FGM. Then the decision goes on to look at sources of protection against possible risks to the daughter. And that's dealt with very extensively in the paragraphs that follow. That runs from paragraph 83 to 113. There's then a discussion about the possibility of internal relocation and avoiding danger by that method. And then there is consideration specifically of Article 8, and that begins at page 671. Now, you'll have seen in Zumbas, Lord Hodge makes the observation that there's nothing in principle offensive about template-type letters. And these letters do follow a template, and that's because the letters are actually written in response to certain headings in the immigration rules. So these headings, Article 8, family life, parent, partner, refer back to provisions in the immigration rules, which is why they're structured in this way. So you'll see Article 8 is considered expressly under the partner route, so that's reference to a relationship with a partner. And then under the parent route, so reference to the children at that juncture, and noting that they're not of 7 years residence. Then there's discussion of private life and the impact of that on the appellant. And then the heading of exceptional circumstances, which again references the interests of a relevant child or another family member. And it says, 148, you provided no information or evidence to establish there are any exceptional circumstances in your case. And then you have a separate section on section 55, consideration. And that begins, the numbering stops at paragraph 149, and then there's a discrete section under section 55, again referencing its consideration, and then setting a number of particular factors that are taken into account. Whether it's reasonable to expect a child to live in another country, level of integration, how long they've been away, and so forth. Any other factors you've raised have also been taken into account. These have also been included in a final and overall consideration, which includes a wider public interest. Then reference to the particular children, their age, the fact that they've been away from Nigeria for 6 months, and discussion of their educational abilities, their English language abilities, and so forth. And those factors don't alter the decision to remove you to Nigeria. Again, you'll note that the FGM issue has already been considered separately. Domestic violence has been considered separately. So threaded throughout the decision letter is consideration of the children's interests. Now, it doesn't say, there's a reference to the guidance. There's no reference to the actual guidance, paragraph 2.7, and there's no interview conducted with the daughter. That's accepted, of course.
There's no reference to whether that was even considered, though, I think, here.
That's right.
Isn't that right?
Yes. So the issue is then the subject of that negative decision.
And how old was the daughter at this?
At that stage, she was 12.
12.
The decision is appealed. You've got the notice of appeal, page 678. The grounds of appeal are 681 in respect of the protection decision, and they're essentially domestic violence and risk of genital mutilation of the daughter.
Yeah.
The mother provides a witness statement. You'll see that, page 686. Through to 691, detailing a number of issues, including matters relating to her daughter at paragraph 30, FGM, paragraph 17 to 20, and the matter then goes before the tribunal for consideration. The first tier tribunal decision is at 708. And the theme of the tribunal decision is essentially that there's a credibility problem with the case advanced by the appellant. She's inconsistent, not believed over a wide range of issues. For example, page 716 to 717, on a range of points about the risk of genital mutilation, the tribunal does not accept the account given by the mother and the risk that's being considered. There's a particular consideration of the risk to the daughter at paragraph 47. Again, with considerable detail on the specialist country information and taking into account the age of the daughter, who's currently at that stage 13, where the risk to girls over the age of 5 appears to be low, and then consideration of the protective mechanisms that are in place. Article 8 is also considered by the tribunal at paragraph 53, and the appeal is dismissed.
So what page is that?
This is at page 719, a very brief consideration of Article 8. So that's the subject of an appeal challenge, essentially issues taken with most aspects of the findings, and the upper tribunal refused permission to appeal. That's at page 732. Paragraph 4. The grounds insist and disagree enthusiastically on the facts, but they do not fairly reflect the reasoning or disclose an arguable error, and then gives an example of that. The decision is rejected, the application is rejected for permission. Then what happens is judicial review application, and you see the pre-action correspondences, page 733, and the pleadings are page 746. At this stage, the applicant introduces a section 55(3) ground of challenge. So, bearing in mind what I've shown you in terms of the bellwether case of JR 137, now we have a section 55(3) challenge. We have the decision which doesn't do some of the things that the Court of Appeal says should be done, and the notice party, not the respondent, the notice party is the Secretary of State, the tribunal are not represented. They engage with the proceedings and a concession is made. So the judicial review succeeds, the upper tribunal refusal of permission is quashed on the basis of the section 55 ground and others, and the decision is sent back to the upper tribunal. The upper tribunal then
To hear the appeal.
to reconsider the permission refusal.
And I think they did it on a rolled-up basis in the end.
So that's a 777 and 779. Rolled up basis rejects the section 55 argument in respect of that, comments on the JG decision, and leave is then sought to appeal to the Court of Appeal. So that's the journey that brings the case before the Northern Ireland Court of Appeal. Again, pausing at that juncture before we get into the CAO decision itself, the approach that was taken in the decision letter and by the first tier tribunal judge, Judge Grimes, would appear to have satisfied the Court of Session on the SG approach, would appear to have satisfied the courts and tribunals in England and Wales on the basis of AJ India, etc. And Arturis, by that stage, had made the position fairly clear as to where the upper tribunal stood. So that was the background in which this case came before the Northern Ireland Court of Appeal. And you have the final version of the promulgated decision before you. Lord Justice McCluskey, Lord Justice Horner and Mr Justice Fowler were the court. And the court, of course, grapples with the facts of the case, but at this stage we now have a judgment which involves directly engaging with the Arturis analysis and defending the JG position in the course of this judgment. So, issue is squarely joined by the Court of Appeal, which is unmoved as to the correctness of the position it has adopted to date, and one can see that quite clearly in paragraphs 72 and 73 and 74 of the judgment, which the Northern Ireland Court of Appeal adopts again and embraces the analysis it adopted in the JG case. There are some concessions in the Court of Appeal's consideration in terms of the consequences that can flow from a Section 55(3) violation, and paragraph 90. The Court of Appeal accepts that in principle a breach of the Section 55(3) duty can be remedied, however unsatisfactorily, by either the first tier tribunal or the upper tribunal. That's the consequence of the effect of the changes in 2014. But it maintains its position as to the overall correctness of the decision in JG at paragraphs 30 and 33 of that judgment. The consequence of the CAO decision is that JG remains good law in this jurisdiction, in our jurisdiction. When another case emerges, as it will inevitably do, on a Section 55(3) point, the approach of the Northern Ireland courts will be that there are absolute obligations in respect of Section 55(3), which must be demonstrated, even if the overall Article 8 analysis is sound. The case will still fail on the basis which Mr Justice Schofield articulated so clearly in JR 137. And the judgment of the Court of Appeal in CAO leaves all of that intact. What it means is that we will have a continuation of binary and mechanistic reasoning leading to successful appeals and remittals back to upper tribunal and first tier tribunal, even where there's been a full engagement with the Article 8 obligations in an individual case. We say the decision in CAO...
unless you can show that it was a trivial flaw or... Yeah.
But what it does do is it leaves open the scope for further public law challenge, judicial reviews running on the Section 55(3) ground. They will get leave because they will be arguable based on the Court of Appeal decision, and the Secretary of State will be making decisions about conceding those. And we will continue to have a differential approach in two jurisdictions of the United Kingdom, which is why, no matter what view this Court takes of the merits of our argument, there is a need for a reconciliation of these differing positions. So the reconciliation in our submission is to align consideration of the Section 55 duty with the approach the appellate courts have taken to other similar duties, like public sector equality duty, Section 71 of the Race Relations Act, Section 75 of the Northern Ireland Act, and to avoid a mechanistic, mechanical approach to consideration, but to look to the substance of whether or not regard has been had to the considerations in question. That's a settled approach to duties of this nature. It's been settled by the Supreme Court, by the Northern Ireland Court of Appeal, by other courts. There's nothing unorthodox about it, and it fits perfectly with this statutory scheme. It doesn't undercut the rights of any appellant, because we know, overarchingly, the Article 8 obligations must be discharged by whatever court's dealing with the case anyway. So there isn't a need to superimpose a secondary decision-making infrastructure through Section 55(3) or Section 55(1). This is an area of law that this court and others have already grappled with in other contexts. And giving expression to the duty in those terms will remove much of the complexity, overcomplication, and scope for procedural appeals that arises with the present interpretation of our Court of Appeal. Now, not all of that is foreshadowed in the Arturas decision, because they don't quite look at the point in that way, but the threads of it can be found right back in AJ India in 2011. The court there was saying, this looks rather like Section 71 of the Race Relations Act. This is how it should be discharged. And if we graft that type of judicial reasoning onto this context, then we will have a workable approach to Section 55 that can be uniform across all the jurisdictions of the United Kingdom. And that, we say, is the answer to this case and this appeal. My Lord and Ladies, I've used slightly less of the time than I had been allocated, and I have to apologise for that, but unless the court has particular questions, those are submissions I wanted to advance to the court orally.
Thank you.
Yes. So, and do you say that there's no difference, or there should be no difference, between the test or how it's applied, depending on whether it's being considered in a truly appellate process or in a judicial review process? How does it play through in both of
I don't
those?
think it makes a difference in terms of how Section 55(3) is interpreted, whether it's judicial review or in an appellate process. The substantive considerations will be the same. The remedies will be different. The outcomes will be different, but it doesn't, I think, impact on the nature of the substantive consideration. Part of the problem is, I think, in some of the decisions, the Northern Ireland courts have been looking at it through a judicial review prism rather than the de novo appeal, but I don't think it makes a difference to the overall substantive analysis.
It would just make a difference, the factor about the FTT being part of the decision-making process wouldn't be relevant in the judicial review.
No, the High Court would still have its own obligations under Section 6 to ensure it produces an Article 8 compliant outcome.
Yes.
You're right, it's not an extension of the Secretary of State's decision-making process.
Right.
I'm not sure it would make a materially different.
So you might, in a JR context, you might pay more attention to the decision letter and what happened at that stage than you would if it was an appeal come up through the FTT.
Yes. And judicial review won't have the same scope for
Remaking.
decision making, and may have the Cart-Galba threshold, which is slightly higher.
Yes.
Those are procedural differences.
I mean, there's a major difference between the two. In a judicial review, the relevant decision maker is the Secretary of State, so you necessarily focus on the decision letter and what the Secretary of State and his official or her officials have done. If there's an appeal, the FTT is the decision maker at that stage, so you focus on what the FTT does at that point.
Yes, I got that.
And I think that's effectively what Lord Doherty said in ZG, that if it's an appeal type case, you've got a new decision maker and you look to see whether that new decision maker, which is the FTT, has complied with the relevant duties.
Quite content with that approach, yes, agreed.
Thank you.
Sorry, yeah. Mr. Glennon, can I ask you just then, on the facts of this case, the decision-making has not considered separate consultation with the 12-year-old girl?
Yes.
At any stage, I'll just say throughout the decision-making process, which I think you accept as a gap?
Well, in this case, it didn't happen. Contextually, is it a problem? One looks to what the issues are.
Yes.
Mother is concerned about genital mutilation as opposed to it. One assumes the daughter is too. That's the import of whatever the mother's saying. There's no one advocating for a position that's antithetical to the child's interests here. Is there a need to engage with the 12-year-old girl to ascertain her views on genital mutilation? Arguably not, particularly when the issue really is the mother's account credible?
Right.
I mean, do we need to talk to the daughter to corroborate the mother's account, which is flawed in many respects? So this is an unusual case in that sense.
Yes.
It doesn't appear on its face to be something that actually is a gap in the analysis when one looks at the issue before the decision maker. And also, it's actually quite a lengthy and detailed decision letter on that issue. FGM, the impact on the daughter. It's difficult to see how it can be analysed any more fully.
So if it's a gap, it doesn't make a difference in establishing best interests?
Exactly. And that's the risk of adopting a formulaic approach. Yeah. We say there's a problem when in fact there is no problem of substance in this case.
I mean, I should say it struck me reading, well, particularly the upper tribunal decision letter, it was taken as read that FGM is a bad thing and would be contrary to the wishes of the daughter. I mean, I was left struggling a little bit to see what asking the daughter for her wishes would add to that.
Well, part of
that's
her.
A platform for the whole decision.
Yes, I mean, the best interest of the child may not to be confronted with a discussion about genital mutilation in this context. The starting position was, this is a bad thing, no one's advocating for it. Why would we be engaging with the child about that? That might be a paternalistic approach, but it may well chime with the child's best interests. Or at least it shows a regard, which is really the test that we're looking at here.
Well, so you're saying if it had been considered, we don't know whether it would have had been considered whether to ask the child or not. Really, the only rational conclusion would become it's not a good idea to say to a 12-year-old girl, your father thinks you should undergo this procedure.
Yes, in a world where the state's position is you should be removed back to that jurisdiction. It's not an irrational call to make that you don't actually engage with the child on those issues. So,
I mean, I wonder whether there's even a prior point that it seems to me that it's only relevant to make inquiries if you need to inform yourself about something which is germane to the decision that you're going to make. Here, the starting point is FGM is bad and is contrary to the wishes of the child. So I sort of struggle to see why would you ask the child to confirm that if that's already factored into the decision making. There may be a separate issue on top of that depending on the maturity of the child and how they might react, it might be a bad idea to ask the child anyway. But I was really focusing on the prior stage.
Yes.
Do you need more? Does the decision maker need more information to answer the question, is FGM contrary to the wishes of the child?
Not at all. It's already known. That's a given. It's priced into the analysis at the start. So this is a very unpromising case to say there's a Section 55(3) breach that requires intervention. In fact,
and one can imagine other cases where the child's wishes may be highly relevant and may not be aligned with the position of the parents, and indeed we've seen examples of that. And then asking the child may be highly relevant precisely to inform the decision maker of relevant matters which they should be taking into account.
Which reflects the good sense in the fourth bullet point of paragraph 2.7, which is where you have parental input and no reason to doubt its bona fides, then they can adequately express the relevant concerns to the decision maker. In the context of this case, mother is advocating powerfully for the daughter's position, which we all, I think, can readily accept will be the daughter's position. It's difficult to conceive of why we would have a remittal back down to another tribunal to conduct another exploration to find out what would the tribunal find out when it's sent back. Using its powers, what would they ask the daughter? They may decide, well, we don't need to ask anything. We already know. Both you and your mum are very opposed to genital mutilation, so we're not going to trouble you with it. No point getting a psychiatric report. We don't need any of that. So what on earth are we doing, remitting it back down to the first-tier tribunal to do it again? This is form over substance. This is exactly the problem. And the problem flows, as I've indicated, from a misunderstanding of the nature of the duty, which the lawyer's correction to that is to say, well, let's look at what have regard means and what that involves. But it also aligns with good sense and a humane approach to cases of this nature. So we say a wrong turn's been taken, a slight divergence has continued. The paths are now quite separate and obviously problematic, and that's why we say that correction is necessary.
Thank you, Mr. McLean. Grateful. Mr. Mulholland.
Thank you, my Lord. Please the Court, my Lords, my Ladies. Perhaps if I start, if I may, with the factual context of this case, because in our respectful submission in many ways, one must construe the informative, evaluative assessment that must be undertaken in circumstances where FGM being paramount to the concerns of the child, it cannot, by extension, simply be dismissed, in this case at least, where my learned friend would suggest it can be construed that it's a bad thing and therefore that has been taken into account. Because unfortunately in this case, and if I may go into some of the further detail around the facts of the case, but ultimately the mother was not believed in terms of the concerns that were raised. And therefore one must look in the broader holistic context of the underlying rationale of the guidance, both in terms of 55.1 and 55.3, as to separate duties, 55.3 being ancillary to, but to quote the phraseology of Lord Justice McCluskey, the handmaiden to 55.1. And when one looks at it in the context of this case, at the heart of this case is a persistent failure on the part of the Home Office to comply with their express statutory duties. And if I may, therefore, in that light, begin with some of the further facts of the case to give perhaps some further flesh to the bones so that the guidance can be construed within that context and the application of the legal principles elicited from that. This was, and upon this within the documentation there appears to be no dispute, that on the 25th of September 2018, a 12-year-old child and a 16-year-old child arrived into Heathrow with their mother. And this was shortly before, as the mother understood it, as she advanced, I would not put in the strongest terms of advocated, but certainly advanced in the course of an interview, subsequently with the Home Office, that they had left Nigeria under the guise of a family holiday, and under the guise of doing so in order to obtain what was necessary, a waiver from the former husband, in order to have the children lawfully leave Nigeria. But in circumstances where their arrival was in weeks prior to when, in fact, the mother understood the FGM procedure would be carried out and performed upon her 12-year-old daughter. And within weeks of arrival into London, they moved on to Belfast, and it may be inferred within that that the reason for moving within the United Kingdom and outside of England and Wales was because of the fact, by inference, the husband would have known they were going to England. And in so doing, this was a lady who left behind, she had an accountancy degree, BSc degree. She had previously managed a bank. And in fleeing the country with her 2 children, she left behind her own parents, her business, her own roots, her own savings account, and in circumstances where 3 days prior to the expiration of the lawfully obtained visa, the holiday visa, an interview was undertaken by the UK Border Agency. And my lady, Lady Rose, has asked the question, well, was she represented at that interview? And the answer is no. She attended alone. She attended in circumstances where neither in the course of that interview nor subsequent, arguably in the discharge of any potential lines of inquiry that may have been pursued in accordance with 55.3 and or 55.1, were any steps taken by the representatives of the Home Office to either speak to or ascertain the wishes not only of the 12-year-old at that stage, 12 and a half, but of her 16-year-old brother. And one, respectfully, in our submission must consider it's not just the rights of one child here, but in fact the rights of 2 in a context where, again, by way of background, the very third answer given to the third question, and we find this at page 621 of the interview, EF page 621 of the bundle. Question posed, can you give me a brief description of what and who you fear? Response, I, as the mother, fear my husband. Consequences of my husband's actions, he may kill me, and have female circumcision performed on my daughter. And over the subsequent pages,
how can we go into this? It's all dealt with in the findings of the FTT.
It is, my Lord, to this point, and that's where I go with this. The findings of the FTT accept the credibility of her account in terms of domestic violence between 2004 and 2013 in relation to the allegations of serious physical assault, including a miscarriage in 2010 that occurred. And the factual narrative in our respectful submission is important for this reason. When one considers the decision letter and the unequivocal manner in which her credibility is simply not being accepted, impels, in our respectful submission, into sharp focus all the more reason why the guidance becomes absolutely essential in its compliance by the Home Office. Because it should not and is not enough under the statutory obligations. Say for cases where it's practicable or not practicable otherwise. AJ India was an 18-month-old child, for example. But in this instance, we have a 12-and-a-half-year-old, 13-year-old by the time of the FTT, with no consideration being given by the Home Office of taking any steps whatsoever in ascertaining what she has to say in her own right and in her own regard. My learned friend poses the question, well, the mother was there to do that. Why did you leave Nigeria? Tell me about the times that your father tried to take you from school. Tell me about the times that your father attended at the home. Were you there at times? Can you tell me what happened when he sought to take you away?
Surely the mother could give evidence in relation to that.
And the problem, my Lord, was that the Home Office disbelieved the mother beyond 2013 in terms of what she said had occurred.
Is the purpose of following the guidance Does the guidance extend to obtaining corroboration of evidence which is disbelieved?
Well, we set this out in a written case. It does not specifically mention corroboration at all, but what it is to do clearly and designed to is to assimilate the best evidence. And the best evidence is that of the child in terms of her own personal concerns and her own personal fears about returning to Nigeria. And there is...
Again, just going back to the procedure before the FTT and then the upper tribunal, if the mother and or her legal representative, because she was represented at that stage, thought that either of the children's evidence was going to support the case in a material way, the evidence could have been called.
It could, my lord, and I do not demur from that for a moment, and that was a point that was raised. And I will lead into this in terms of its MK as one creative assessment or one creative suggestion by Lord Justice McCluskey endorsed and CAO deals with in terms of at the fact-finding before the FTT or otherwise, what steps could be taken and by whom. But the starting point with all of this, of course, is what we seek to therefore do is the Home Office is granted absolution in terms of their failings under the statutory duty, and in real terms, the onus then falls upon the shoulders of the applicant. Now, there may be instances, of course, and the spectrum of cases outlined within MK Sierra Leone where there could be instances where someone has experienced legal representatives who are conversant and take the appropriate steps if they can obtain funding to do so. There will be cases whereby, for whatever reason, that does not happen. And other cases, again, where the individual is either not represented before the FTT or, in fact, cases do not get beyond the decision letter. And that's the difficulty with trying to pigeonhole this into one particular category, because this guidance is meant to cover all aspects of dealing with the welfare of the child and to promote and safeguard its best interests.
Just going back to the procedure in the FTT or the upper tribunal.
Yes.
I mean, I would have thought that ordinarily the FTT or the upper tribunal judge is entitled to expect that, particularly where people are represented before them, that the case as presented is the case they wish to present, and it's not the FTT or the upper tribunal's business to go behind that and try and think of other cases or other evidence that might be called but has not. I mean, is that wrong as an understanding of the procedural position?
Well, the procedural position, I wish I could give you a very straightforward answer, my lord, and I have two questions that you've properly posed, if I may answer. First of all, in this instance, of course, no further evidence was called beyond the mother being called to give evidence and beyond the witness statement that she provided in advance. But unfortunately, there was no consideration given to the guidance, either by the lawyers in terms of any substantive referral to the guidance, nor in fact by the court. And that cannot be left with the mother, nor can it be left to be the fault of the mother. And the surrogacy principle, and Grace and O'Connor before this very court makes that very point, where the lawyers are at failure or failing in their part, and I'm not criticising those lawyers, but where there's perhaps not been a discharge of the professional duties to ensure the court has everything before it, in this instance, should not be to the prejudice of the individual. And therefore, in this case, at the point at which it comes before the FTT, the Home Office, as one will see at page 708, there's no appearance by the Home Office. There's no objection taken to the non-appearance, no adjournment is sought. But we have a situation, therefore, that the decision letter, which respectfully, whilst my learned friend says, well, it's threaded through the content of that letter, that the interests are given due consideration. We take issue with that. But even when we get to the FTT stage, no one is appearing on behalf of the Home Office. And what we therefore have is a reversal of one onus back onto the mother to satisfy a court in circumstances where when the court comes to make a properly informed evaluative assessment, it does not have all the evidence before it that it could or should have when one then gives due consideration to Article 8. And it is in those circumstances that we do respectfully submit that in this particular case, and Judge Grimes, in the course of her findings, accepts to a point that there had been domestic violence, but due to the inconsistencies between 2013 and 17 of where the mother was resident and where they'd moved to and where they stayed and so on and so forth, that the claims around FGM and the claims of domestic violence in terms of the mother advancing her own case were not sustainable. Yet when one considers that in the context of the guidance, and yes, on one level, and the MK decision endorsed in CAO gives a range of possibilities as to who in fact can carry out what assessment at the FTT stage. But ultimately, the suggestion by Lord Justice McCluskey is that in many instances, the person best placed to do that, in fact, is the Home Office, and is best placed to do that by reason of the framework and structure around the guidance. And perhaps if I may return to the guidance for a moment, with your leave, there are some other aspects of the guidance that we respectfully submit are relevant in the instant case, but also generally in terms of the application of the principles. And at 1529, Mr. McGleenan has really touched upon several aspects of this, but the starting point, just to perhaps re-emphasise at 1533, subparagraph 6.
Yes.
And this is in terms of the obligation to follow the guidance, and as highlighted in bold in the guidance issued, of course, by the Home Office itself, the last 4 lines, this means they, the Home Officer, its officials, must take this guidance into account, and if they decide to depart from it, have clear reasons for doing so. One does not find in the decision letter anything that addresses this either directly or indirectly.
And it's a bit of an odd sentence, that, because it's difficult to explain clear reasons for not having regard to the guidance without actually having had regard to the guidance.
I respectfully agree.
So it's not really clear what it means.
One more.
Presumably it means that if they decide it would be in the best interests of the child to stay, they have to explain why that's overridden by other reasons that support removal. That must be what it means.
It could be, my lady, one practical consideration may be, for example, if they're aware of the fact that the child is an infant, for example, that provides a reason why an assessment in certain circumstances may not be necessary, fact dependent, of course.
But that wouldn't be departure from the guidance, that would be compatible with the guidance. That's the reference to practicable, I thought.
That is the reference to practicable.
So you don't have to give reasons in that case.
But in this instance, the application of that, and that's part of the thread of the jurisprudence through the decisions that Dr. McGleenan has opened to you before the courts in Northern Ireland, where a sense perhaps of frustration after 10 years as voiced within some of the cases, that the guidance is neither being followed nor, in fact, even being considered. And certainly in the context of this case, for Judge Grimes, therefore, before the FTT, to come to an informed assessment and to evaluate the evidence placed before her, she does not have the benefit, therefore, of other information. And if no other information is to be provided, the basis upon which consideration of the 55-3 guidance is not necessary. And by reason of that, when one steps back to look at the actual framework of this guidance, and Mr McGleenan has touched upon from Part 1, 1.1 onwards, the various other bodies, organisations in compliance with Section 11. Article 3, I don't need to touch upon that, it's been open to the court. But there's a clear emphasis. Part 1 also applies equally to the Secretary of State as it does to all other state agencies who come within this broad umbrella. But the emphasis being to create and maintain an organisational culture and ethos that reflects the importance of safeguarding and promoting the welfare of children. And that's cited within the guidance not open to you at the latter part of paragraph 1.6. And if one considers that ethos and culture in the context of this case and the context of the judicial decisions emanating from Northern Ireland, Mr. Justice Schofield makes the same observation. There appears to be a disregard for regard to the guidance, if that makes sense. And the onus being on the UK Border Agency at 1.6 to make effective arrangements. And part and parcel of that, as one goes through aspects of the guidance, particularly at Part 2, which is exclusive to the Border Agency, that includes, at page 1544, not only a development of the policies at 2.13, but in fact at 2.14, the Border Agency must ensure that members of staff are appropriately trained with regard to their duty to safeguard and promote the welfare of children. This goes well beyond a mere consideration, respectfully, in terms of ascertaining wishes and feelings. There must be a framework and structure, policy guidance in place. And when one looks at 2.15, fourth line down, all agency staff should have a general understanding of children's issues, while those who work brings them into contact with children, directly or indirectly, should have more in-depth training. And as part of that, at 2.16, the recruitment and vetting procedures must ensure new members of staff and those existing employees who move to posts with contact with children work safely and competently with children. In other words, the guidance provides a framework and structure that is to give the foundation so that when one discharges the 55.1 obligation, it does so with staff working in this field when they have to come into contact with children to ascertain the views of the child, not merely their wishes and feelings, but their views. They have to take them seriously. And it can give rise, in certain instances, to interagency cooperation. So there is a broader structure at play than the narrow consideration of whether a child should be asked questions or not. The idea being, when one considers the promotion of the safeguards of the interests of a child, particularly when dealing with children, and the jurisprudence around that, that a primary consideration that must evolve in relation to this is in fact reinforced by the structure that must be put in place. And what one finds throughout the body of the guidance, for example, at 2.14 in the preceding pages of 1542, at 2.4 it reads, the UK Border Agency's main contributions to safeguarding and promoting the welfare of children include ensuring good treatment and good interactions with children throughout the immigration process. So again, there is an anticipation of interaction with the child. Again, whilst touched upon in passing at 2.7, the sub-bullet points of every child mattering, even if there's someone subject to immigration, the best interest of the child will be a primary consideration, although not necessarily the only consideration was opened, but also In terms of the role of the parent, and my learned friend emphasised in this case, that is relevant, and yes, it is. But it is the consideration in the context of they have primary responsibility, but not sole responsibility for advocating and ensuring that the interests of the child have in fact been determined, ascertained, and the evidence base obtained in order that an informed decision can be made, and whether that's before the Home Office officials or before the tribunal itself. And thus...
But I mean, you've been discussing the rejection of the mother's claim, but suppose the mother had not put forward FGM as a basis for claiming asylum. What would the duty then comprise under Section 55?
The duty may still arise in the context of the domestic violence claim.
Right, but you're not going so far as to say that that the duty includes raising potential issues that have not been raised at all by the parent? So you're not saying that if the parent isn't concerned about it, that it's still some obligation on the Home Office to pursue that, or?
In this case, no.
Right.
But one may have cases, for example, where the interests of the child do not correspond with that of the parent.
Right. So you would accept that the obligation on the Home Office, or the duty on the Home Office, to proactively raise issues which are not raised by the parent with regard to the best interests of the child are triggered only if there is something that is apparent that indicates to the decision maker that there may be an incongruity between the interests of the parent and the interests of the child.
In this case, yes, and that comes back.
Well, I'm just arguing as a matter of principle.
The guidance does seem to give consideration to instances where, for example, there may be a risk of trafficking or abuse of that nature, where again, obviously, the parent or the individual, the guardian, will not clearly flag those with the officials. So it would be difficult to shut that down on a general basis, but certainly in the context of this case, 3.7 is given effect essentially, in our respectful submission, is where the primary responsibility of the mother is to inform them of her concerns and the risk of FGM, but having done so, then it should, at that juncture, transfer to the representative of the official of the Home Office to ensure that, as they're trained to do, or anticipated they're trained to do, that they take the steps that they deem necessary in accordance with the guidance thereafter.
I think, I mean, it does. Are you really saying this comes down, as I think was discussed earlier, to proper evidence gathering and asking the right questions?
Very much so.
And are you saying then in every case that where you have a child of an age and maturity as these children would fall into a category in, say, family law, where you would routinely get their wishes and feelings? In every case that you should have a Home Office official speak to children, or only when the antenna is raised for various different reasons, like query trafficking or other issues? Because I wonder in this case, was there a red flag that would lead you to need to speak to the children, given the issues that were clearly of concern about FGM, for instance?
To put such a broad responsibility in each and every case, it deem, in terms of going back to resources, proportionality, may go too far, but certainly in instances where there is some degree, whether prima facie evidence or some form of red flag, then that obligation should trigger.
Yeah.
Without being fact, sorry. Okay.
No, please, I stop.
Without being fact specific, one can see instances where, on a simple resource basis, it may be entirely impractical to do so in all circumstances, and hence the have regard to aspect of this. And it's something, if I may take a look at again overnight, some of the cases that have been cited today that are not in the written case for the appellant, before I deal with that in any detail, but have regard to perhaps places of duty, but in the context of the discharge of that duty, there may be instances where the official has done all that needs to be done with those factors in mind.
But that's not this case?
That's not this case.
Because of the mother, because you say the mother's account wasn't seen as credible?
Yes.
Is that the core of your argument?
That is the core. That is the core. And part of the account within the body of the interview, it relates to a stage, in fact, where the child would have been 9, 10, 11 years of age when incidents that she detailed, and this is at 2015, 2016 and 2017, so that the child would have been of a sufficient age, and certainly the son would have been of sufficient maturity, that if any steps had been taken to ask either of them, or to speak with either of them, engage with either of them, then it may have provided the very type of evidence that is absent in this case. And going back to my Lord Sale's question to me earlier, what one finds in this case is therefore where there is no discharge of the obligations upon the Home Office, it is the mother or the applicant having to step in to fill that lacuna. And there is nothing within the guidance, far less Section 55(1), that places that onus on the individual seeking asylum. That's not to say that as they bring their claim, they should have to establish their claim, but this places an added burden on the individual when in fact the resources of the state, the very guidance drafted by the Home Office and the purpose for which that it's put in place, are not complied with. And therefore, yes, whilst the individual should present whatever evidence he or she may have on their behalf of their child, whatever it might be, that is only one part of the analysis that the FTT should conduct.
But how does this work in practice? When you have the FTT hearing, the mother gives her evidence. At that stage, by the close of the hearing, you don't know whether the FTT is going to accept her account as credible or not. How do they then indicate that they're not accepting it in a way which then, you say, triggers the need to get some corroborative evidence from the children?
It really comes back to, before the hearing itself, the use of the case management powers, and whether before the substantive hearing, the case management powers of the FTT should be discharged. I wonder if that's an opportune time just maybe to turn to those briefly, if I may. We hope these have reached the court before today. By agreement, we felt it may be of assistance to have these available. These are the Tribunal Inquiries, First Year Tribunal Immigration and Asylum Chambers Rules of 2014. If they're not, I can park it and ensure that they're with the court overnight.
We have them electronically. They seem to have come in today, just before midday. They've been added to our...
They've been added. I'm sorry they've arrived so late.
So these are the 2014 rules which came in following the change?
Change, yes. Indeed. Yes, thank you. And it's...
Thank you.
Rule 4, my lord, of the... Well, sorry, I should start really with Rule 2. And it's in very small font in mine. It's internal page 3, Rule 2, with the subheading overriding objective and parties' obligation to cooperate with the tribunal. And that really is the starting point. It's the parties' plural obligation. And to subparagraph 1, the overriding objective of these rules is to enable the tribunal to deal with cases fairly and justly. And that includes, subparagraph 2, subparagraph C, ensuring so far as practicable that the parties are able to participate fully in the proceedings. D addresses the use of expertise, using any special expertise of the tribunal effectively. And at subparagraph 4, parties must help the tribunal to further the overriding objective, and B, cooperate with the tribunal generally. So clearly,
I mean, in our case, both the mother and the children were able to participate fully in the proceedings. Any of them could have given evidence.
yes, and the mother did give evidence, my lord. But whether the individual has an appreciation of issues around the guidance, the application of the guidance, in the context of Article 8 or otherwise, does not limit the information that the FTT should have in order to come to, as it's described in the rules, dealing with the case fairly and justly. And that's where the onus must still fall, we respectfully submit, on the Home Office or the Home Office officials, because in circumstances such as this, where it's simply left to the mother to establish her case in a vacuum, then that, we respectfully submit, is not consistent with the objectives that the 2014 rules set out to achieve. And again, the general powers are then specified, and definition is brought within that Rule 4, subparagraph 3, with a litany of various specific powers that the tribunal may enjoy, including the D, requiring or permitting a party or person to provide documents, information, evidence, or submissions. And it again is in that context, if the Home Office official has fulfilled the obligations and has complied with the duties, then there may be a body of evidence to be placed before the court. And it's in circumstances, of course, where it's been gleaned or obtained by someone from the Home Office who's been trained in how to properly deal with children, what the issues may be around their best interests and their welfare, and provide that and present that properly and fairly to the court. And the court is being denied the benefit of that in these cases. And certainly the suggestion that there is, bearing in mind, if I adopt the phraseology, the barrier that was put in place from 2014 of the remittal back to the Home Office decision maker, we make reference in, I believe it's paragraph 16 of our written submission, to that still being available, and that what that in fact should say, and I need to correct that error, it's a remittal by proxy is one means by which that can still be undertaken. And what we mean by that is, and this emanates from MK Sierra Leone, which again is endorsed within CAO, and if I may very briefly turn to the paragraphs as relevant to that, it's at page 1356, paragraph 37, and paragraph 38 of the MK decision.
Paragraphs 37, 38.
37, 38, my lord, thank you.
That's a moment. We have to change back to another document.
37 deals first of all with the procedural regime in terms of the rules. Their effect from the 20th of October. The umbrella power as set out that we've just been through. And then at 38, the observation of the court was as follows: we consider that there could be no objection in principle to an order of the tribunal, the effect whereof is to require the Secretary of State, rather than the tribunal, to perform the two duties imposed by Section 55. It continues, there is no jurisdictional bar of which we are aware. It has been long recognised that there is a category of cases in which it is open to both tiers to allow the appeal on the basis that the Secretary of State's decision was not in accordance with the law without further order, thereby obliging the Secretary of State as primary decision maker to remake the decision, giving effect to and educated and guided by such correction and guidance as may be contained in the tribunal's determination. So what we elicit from that...
That looks like a remittal. That looks like...
A remittal by proxy is the terminology of...
But if a remittal's ruled out by the change in the rules, I'm struggling to see how this guidance can be correct.
It is expressly ruled out that there can be no direct remittal back from the appellate court structure. But in instances of then trying to grapple with how to get the best evidence before the court, this is one proposed suggestion advocated by the court in this case to ensure that there is an effective means by which that evidence can in fact be gathered. So in other words, it's to ensure two things, I suppose.
This paragraph 38 was decided after the remittal was abolished.
And decided in circumstances, of course, where this is the decision at that point in time of the upper tribunal in trying to then grapple with how do we best achieve obtaining the evidence to conduct the assessment under Section 55, which complements Article 8.
I mean, why wouldn't the tribunal not simply make an order under its case management powers under Rule 4.3 requiring someone to provide evidence to the tribunal?
It could also have done that, yes. And in circumstances whereby the powers apply to both parties, that potentially was one option. But when one goes back to the overriding concern and the subtext of ensuring that the compliance with 55.1 and due regard is given to, is given to 55.3, this appears to be the court grappling with how you give effect to that in these circumstances. Generally, where one's sitting with limited resources, with a caseload before either the first tier or upper tribunal, and trying to ensure that the statutory obligations of the Home Office are given some degree of effect, where otherwise it again falls back upon the individual to do so alone. So
what you're saying, they're saying here, no, you can't remit it anymore, but you can just say the decision was not in accordance with the law, and the decision of who is quashed then? Whose decision is not in accordance with the law? Because you've got the first tier tribunal's decision.
At this juncture, the application of the rules being that if the first tier tribunal has not had the benefit of all of the information to make a proper assessment, and or if the decision maker has not conducted a proper assessment, and it comes before, for example, the first tier tribunal, the judge may take a practical view of this and say, well, I have powers under the rules where I can now direct you either to reconsider this or to bring before me the evidence by conducting an interview or obtaining expert evidence, whatever it may be. But it's by reason of the fact that there is no compliance with the obligations in the first instance, the courts are having to grapple with stepping into the shoes and perform the functions that are not being performed on the part of the Home Office.
Mr. Mulholland, I'm very puzzled by paragraph 38. This is paragraph 38 of MK, which, as I understand it, was handed down after the change in the rules took place.
Yes.
The change in the rules took place between JO and MK. It's flatly contradicted by what the Court of Appeals said in paragraph 62 to 64 of the present case, which says that there is no scope for a tribunal to refer back
Indeed.
in this way. Therefore, it has to be dealt with by the tribunal itself, or by remitting it, by the upper tribunal itself, or by remitting it to the first-tier tribunal. And that brings in the range of powers which are available to the tribunals, which you've shown us.
And as part of that, my Lord, the interpretation, because the Court of Appeal decision in this instance endorses the approach of MK, and with that appears to also endorse this as being one means by which, indirectly, the steps can still be required of the Home Office.
Forgive me, but how does the Court of Appeal decision in the present case endorse this passage in paragraph 38 of MK? It seems to contradict it.
There is the... If Lord will allow me a moment whilst Mr. Anthony
I
gets
have in
us
mind
through.
paragraph 62 to 64 of the appeal in the present case.
It's found, my Lord, at paragraph 44 of the present decision, which is page 1169.
Well,
And
we're
this-
using a separate version, aren't we? Corrected version. You're talking about the Court of Appeal's judgment in
Yes,
this case?
Lady, yes. I believe it's still...
Well, paragraph 44 sets out
So it sets out...
paragraphs 35 to 39.
Yes, which is the MK.
Yes. It takes several pages to do that.
It does. It does. And it certainly goes into some degree of detail, and one will find the specific paragraph cited at page 1172, still within that paragraph. And it just immediately above paragraph 45, the one sentence observation of the Court of Appeal is the passages reproduced above require no elaboration.
Yes. But then later in the judgment of the Court of Appeal, it specifically addresses the powers of tribunals, whether the first-tier tribunal or the upper tribunal, to remit to the Secretary of State. It concludes that there is no such power.
It does, my Lord. And one, perhaps this is one illustration of trying to grapple with the difficulties, the practical difficulties that have arisen by reason of the failure to comply with the duties on the part of the Home Office, and with the Court observing we no longer have the ability to remit it directly. Hence the phraseology, my Lord, perhaps inelegantly today, of it's almost a remittal being suggested by proxy, that using the court powers of the FTT, then this is another means by which the purpose can be achieved, which is to direct the Home Office officials to obtain sufficient evidence that can be brought back to the court to conduct the assessment at the FTT hearing. But all of this comes back to the difficulty that arises when the guidance is not being considered in the first instance, and how courts, therefore, are trying to find ways in which this can be effectively undertaken to ensure that a proper evaluative assessment in accordance with, as it is here, Article 8 can be conducted. But
Are you saying that if there's a breach of Article 55, then that is within that category of decisions which are not in accordance with the law, where MK seems to suggest that there is a remedy open, which is just to quash the decision of whom, I'm not quite sure, and just leave it at that, which seems a rather unsatisfactory way to leave it, because you've got here the decision maker is effectively the FTT, isn't it?
Indeed.
But paragraph 62 makes it clear that when they refer to MK, it's in the context of the statutory arrangements then prevailing, which are then distinguished. So it's clearly recognising that the position has changed. Halfway down 62.
It is, my lord. But it's with that in mind that this, whether call it a pragmatic or practical approach, is being mooted by the court to, as I say, respectfully fill that gap. I'm mindful of the time, and I wonder, perhaps there's one other matter, if I could respectfully, very quickly draw to the court's attention this afternoon. And it is, again, dealing with the question of, in this instance, has been advanced that the mother can advocate for the child. We can infer and imply from that all that we need to know, or the court would have needed to know, and therefore, regardless of whether the duty is discharged or not, no harm is done. And if I may, the case has been opened already. It's the ZH decision and the judgment of Lady Hale from this court. And just two very brief extracts, if I may, that have not yet been opened to the court, please. And one finds this, again, under the subheading of, it's page 1511, the subheading just prior to paragraph 21, UNCRC in the best interests of the child. And Mr. McLean had touched upon aspects of this. And then what one finds is at page 1515, under the subheading Consulting the Children, there is an express reference at paragraph 34 to Article 12 of the UNCRC. And so paragraph 2, well, 1, state party shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child. 2, for this purpose the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child. And that's then considered, and this has been opened in the context of EM Lebanon.
Well, I mean, it goes on saying either directly or through a representative or an appropriate body. So, I mean, again, I'm slightly struggling because, I mean, first of all, the mother did express views on behalf of the child, which are not controverted. And secondly, in looking at Article 12.1, the party shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters. Again, the child, in fact both children, could, if they wished, have given evidence to the FTT. So
there it is, that, my lord, but if I may read that in conjunction with paragraphs 36 and 37, briefly, please. 36 begins with the important thing. And this is a read across from AF, but the important thing, Lady Hale observes, is that those conducting and deciding these cases should be alive to the point and prepared to ask the right questions. Now, that is not an obligation clearly on the parent. And furthermore, at 37, 5 lines at paragraph, so paragraph F, 37F, but the immigration authorities must be prepared at least to consider hearing directly from a child who wishes to express a view and is old enough to do so. And then H, children can sometimes surprise one. And it is that observation that we respectfully say resonates in instances such as this, when it cannot be taken for granted what can or cannot be gleaned from the mother. Children can sometimes surprise one. We have a 12 going on to a 13-year-old, as well as the 16 going on to 17 years of age, who may have assisted, but specifically with the focus and emphasis on the daughter. It therefore accords with why the framework is in place.
But the context there, paragraph 37, is where the interest of the child may not be the same as the parents.
It is in that context, my lord, but nonetheless the observation rings true, we respectfully submit in this instance, where we simply do not know, in circumstances where the mother's credibility is not being accepted, what in fact the child could add to the factual matrix and the determination that would flow from that. I wonder, I say it's 4 o'clock, if that's a convenient point at this juncture.
Yes. Thank you, Mr. Mulholland. Grateful. We'll resume tomorrow morning then at 10:30. Thank you very much.